Hi, welcome to our channel of IGNOU Audiobooks, Indira Gandhi National Open University, School of Law, Sol, Diploma. Diploma in Paralegal Practice, DIPP. BLE 003 Law and Vulnerable Groups. Block-1 Women and the Law. Unit 1 Understanding Gender-Based Discrimination. 1.1 Introduction. The term, gender, is being increasingly used in common parlance like never before. What used to be found only in sociology and humanities texts is now quoted frequently in the columns of the daily newspaper. Gender is a term that is quite often confused with the term sex. While the sex of a person, being male or female, is determined by several biological factors such as genetic makeup, gender identity is something that has been constructed or ascribed to one by society. We use the term construct since it is imposed upon one and is not a natural phenomenon. Thus, being born man or woman and possessing those physical attributes that distinguish one from the other, sex, is biological, but that women should be meek is a gender attribute that is ascribed to women by society. In other words, women are socialized into being submissive and meek just as men are socialized into being aggressive and tough. This ascription of qualities and behavior begins in the home and leads to considerable discrimination in treatment between boys and girls. Girls are expected naturally to help out with household tasks and to take on nurturing and caring roles in addition to attending school, while boys are encouraged to play freely when they are not at school. The assumption within families is that since boys will anyway have to undertake the onerous responsibility of breadwinning for the family later, they should be given every opportunity to be free of responsibilities when they are young. There is a clear link between gender roles and the high dropout rate among girls in schools. Since the destiny of all girls is to marry and bear children, their education is considered dispensable. Women face such discrimination and differential treatment in various other spheres of life too, as women's status and the way in which they are viewed have been shaped by society. It seems to follow that they will be subject to similar discrimination within the legal system and in the way they are viewed as legal subjects, and therefore, injustice outcomes. In this unit, we shall examine some of the stereotypes about men and women and the reasons for this. We shall also examine the impact of gender relations on women's human rights and the response of the law to addressing their position in society. 1.2 Objectives. After studying this unit, you should be able to 9. Explain the manner in which a patriarchal society has constructed gender. 9. Analyze how women's rights are violated as a result of gender stereotyping and gender roles. 9. Explain the difference between productive and reproductive work and how this leads to discrimination between men and women. And 9. Analyze the response of the law, international and national, to addressing women's needs. 1.3 Patriarchy. In order to understand the concept of gender more clearly, it is necessary to examine the status of men and women in traditional societies. Historians and sociologists have recorded that the movement of societies has been from the matriarchal rule of the mother, where women definitely enjoyed a more equitable relationship with men, to a patriarchal rule of the father society in which men play a dominant role. Although it is not clear exactly how and at which point in time the transition happened, One theory is that as the movement from an agricultural economy to that of a hunting economy occurred, women became more homebound since they had the responsibilities of childbirth and rearing. At this point, as men began going out to hunt, they began to transact more with the outer world, learning about trade and barter and a monetized economy. Women were denied this due to their being tied down by childcare and household responsibilities. This led to a heightened sense of their work and its importance. In men, women's role in reproductive work began to be rated less as compared to the more visible, successful roles that men were playing. 1. Women are oppressed because the administration of the household lost its public character and it became a private service. 2. It is important to understand that patriarchy as a system continues to be perpetuated since it benefits men and puts them in a position of power with the women. Women are dismayed and witting partners in the perpetuation of the patriarchal system in different ways, such as gender indoctrination, that is, role stereotyping of men and women, denial of education of knowledge of their own history, dividing the men from one another by defining norms of behavior, conferring respectability and attributing deviance according to their sexual activities, and discriminating against women in access and control over economic resources and political power. 3. We shall discuss the effects of patriarchy in creating categories of productive and reproductive work later in this unit. We will also examine how such patriarchal control benefits men and makes it possible for them to control women. 1st March 2001 Gender stereotyping of roles and behavior. In this section, we shall try to understand how patriarchy has manifested itself in gender stereotyping of roles and behavior. Gender stereotyping means the ascription of certain attributes and roles to men and women. For example, that men should not cry is a gender ascription of behavior. Therefore, crying men are seen as weak, exhibiting their vulnerability and not living up to their male image. As a result, it is expected that men keep up a stoic appearance even in situations of extreme sorrow and loss. This is an ascription by a patriarchal society as being natural, while the irony is that the most natural thing for any human being, man, woman or child to do in the face of extreme loss or pain is to cry. Similarly, women are naturally expected to be caregivers, although both men and women are equally equipped and capable of taking care of children. That only women can give birth and breastfeed is determined by biology. However, there is nothing to show that only women need look after the child after it has been weaned. It is because men in India as well as in other societies are socialized into not taking up child care responsibilities and leave it to women to take on what is considered their primary responsibility, that there are no provisions for paternity leave in India in most institutions. Where there is a provision, very few avail of this facility. 1st March 2002 Modes of patriarchal control. There are numerous ways in which patriarchal control is exercised. X. Control over women's productive power or labor. This is discussed in greater detail below. X. Control over women's reproduction and sexuality. Decisions about frequency and number of children and family planning are rarely made by women. Child-rearing practices are influenced by gender-based socialization, and girls are schooled to be women, and boys to be men. as described in the gender stereotyping section above. In addition, women's bodies are controlled by men to satisfy their sexual desires to a great extent, as is evidenced by the practice of prostitution and marital rape. Control over economic and material resources. Women's right to own and control property still remains a distant dream despite legal guarantees. Even in matriarchal families, the actual control of property lies with men. More importantly, women themselves are considered the property of men and, therefore, subject to decisions made by them. Control over decision making in all aspects of women's lives. This is done through economic, political, religious, legal, social, and cultural institutions. Restrictions are imposed on their mobility. Restrictions, such as the clothes she should wear, the timings she should keep, the people, especially men, she should talk to, all become important means of control. 1st March 2003. Productive and reproductive work. Both men and women do productive work for remuneration. However, it is the visible labor of men which is paid work that is valorized by patriarchy, and the work that women do of childbearing and rearing is not valued and is consequently unpaid work. To quote another example, in many agricultural and tribal communities, both men and women plow the land. However, the myth that women cannot plow their land since it is arduous work is propagated by a patriarchal society, leading to stereotyping of work roles as well. On the face of it, one could argue that men not crying or women assuming child or elderly care responsibilities are not issues. However, such ascription of gender roles and attributes becomes questionable because it forces men and women into unnatural roles and behavior and sets up hierarchies that lead to unequal and unhealthy power equations. Similarly, productive or paid work, which most men are socialized to do, is more important and valued than the reproductive work that women do of bearing and rearing children, and of cooking, cleaning, washing, and creating a home. The latter is therefore unpaid, and for that reason, valueless. Research conducted by the United Nations Development Programme, UNDP, for in 1995 has computed the unpaid reproductive work that women do to be in the region of $11 trillion annually. This is the value in wages that societies would have to pay those who render services of cooking, cleaning, and washing, but which women do without any remuneration in millions of homes. This report has been followed by several nationwide studies taking up the exercise of computing the value of unpaid work and of advocating that this be considered in computing national income statistics. The reproductive work that women do actually frees men to do their productive work unhindered, but this contribution is largely kept hidden and ignored both in the home and by policymakers. This is why the demand of the women's movement has for many years been that the value of the unpaid work that women do should be taken into consideration when computing the gross domestic product of economy, since it is a significant and valuable contribution. However, it is not considered so by society and, therefore, by policy makers. If this unequal equation between men and women is to change, it is clear that much more work needs to be done to enable men to express their emotions openly without feeling pressurized to be manly. There may be men who may want to explore caring and nurturing qualities that are inherent in them and to have the luxury of not always being the breadwinner. Using the same yardstick, there could be women who may not always want to be placed only in a nurturing role, but who would also wish to explore their inherent managerial, entrepreneurial, or other latent capabilities. However, there is very little space in a patriarchal society to interchange such roles, and much more importantly, to share equally in those roles. The sharing by men and women of reproductive work in homes could lead to a more healthy and harmonious relationship between men and women, and to a more equitable society based on mutual respect and understanding. This can come about only if there is awareness that an unequal exercise and enjoyment of power and privileges by men at the expense of women is unjust. To change this will require the commitment and efforts of both men and women alike. The devaluing of women's work is not confined to the reproductive arena alone, but is also visible in the productive work that they do as well. This is manifested in wage disparities between men and women, in denying women the same opportunities for promotions, and in the fact that the work that they do is exploited through the devaluation of their productive labor as well. Men also exploit women's labor by selling their bodies as in prostitution. 1 point for gender inequality in the family. Response of the law. The biases that operate against women in the family are reproduced in the response of the legal system to violation of women's rights. There have been attempts made by activists and those interested in legal reform to ensure that the system changes and is made more responsive to women's lived realities. The need for an international legal regime that would advance women's human rights came about as many attempted to understand the inadequacies of the legal system to respond to women's struggle to be treated as equals. We shall now examine how the law has responded to the needs of women, both at the international and national levels. 1st April 2001 Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW. One of the most important steps taken to advance the protection of women through rights and the law in the international arena is the adoption of the Women's Convention, CEDAW. Although there were provisions in earlier international conventions through which women could claim protection, such as the Universal Declaration of Human Rights and the International Convention on Civil and Political Rights, these provisions did not deal comprehensively with the specific realities of women. The main international human rights organs like the UN Commission on Human Rights or the Human Rights Committee, under ICC-PRA, did not appear to deal specifically with violations of the human rights of women except in a marginal way or within the framework of other human rights issues. 5. CEDAW was adopted unanimously by the United Nations on December 18, 1979 and entered into force on September 3, 1981. The Women's Convention is like an international Bill of Rights for women which is ratified by state parties who then agree to abide by the terms of the convention. Understanding that women's equality can come about only if fundamental changes occur in the home, CEDAW observes that a change in the traditional role of men as well as the role of women in society and in the family is needed to achieve equality between men and women. 6. Consisting of a preamble and 30 articles, CEDAW defines what constitutes discrimination against women and sets up an agenda for national action to end such discrimination. The Convention defines discrimination against women as any distinction, exclusion or restriction made on the basis of sex which has the effect or purpose of impairing or nullifying the recognition, enjoyment or exercise by women, irrespective of their marital status, on a basis of equality of men and women, of human rights and fundamental freedoms in the political, economic, social, cultural, civil or any other field. By accepting the convention, states commit themselves to undertake a series of measures to end discrimination against women in all forms, including to incorporate the principle of equality of men and women in their legal system, and abolish all discriminatory laws and adopt appropriate ones prohibiting discrimination against women. To establish tribunals and other public institutions to ensure the effective protection of women against discrimination, and to ensure elimination of all acts of discrimination against women by persons, organizations or enterprises. The Convention provides the basis for realizing equality between women and men through ensuring women's equal access to and equal opportunities in political and public life, including the right to vote and to stand for election, as well as education, health and employment. States parties agree to take all appropriate measures, including legislation and temporary special measures, so that women can enjoy all their human rights and fundamental freedoms. The Convention is the only human rights treaty which affirms the reproductive rights of women and targets culture and tradition as influential forces shaping gender roles and family relations. It affirms women's rights to acquire, change, or retain their nationality and the nationality of their children. States parties also agreed to take appropriate measures against all forms of traffic in women and exploitation of women. Countries that have ratified or acceded to the convention are legally bound to put its provisions into practice. They are also committed to submit national reports, at least every 4 years, on measures they have taken to comply with their treaty obligations. As of May 2009, 186 states have ratified or acceded to the treaty. 7. Two institutions within the universal human rights system are concerned exclusively with women's rights. The older of the two, the UN Commission on the Status of Women, is formally the body with rights. It was established at the same time as the Human Rights Commission, but it has been a less effective and influential body. The second more significant and influential organ has been the committee formed under CEDAW as a body of independent experts from diverse backgrounds like sociology, medicine, international relations, education, political science, law and government. The task of the committee is to monitor states' efforts to meet their obligations through review of periodic reports submitted by the state parties. 8. The optional protocol to CEDAW, which enables private parties and NGOs to petition the CEDAW committee with complaints and bring to its attention information about women's rights violations in any part of the world, was adopted by the UN General Assembly on October 6, 1999 and entered into force on December 22, 2000. By ratifying the optional protocol, a state recognizes the competence of the Committee on the Elimination of Discrimination Against Women, the body that monitors state parties' compliance with the convention, to receive and consider complaints from individuals or groups within its jurisdiction. The protocol contains two procedures. 1. A communications procedure allows individual women, or groups of women, to submit claims of violations of rights protected under the Convention to the committee. The protocol establishes that in order for individual communications to be admitted for consideration by the committee, a number of criteria must be met, such as that domestic remedies must have been exhausted. 2. The protocol also creates an inquiry procedure, enabling the committee to initiate inquiries into situations of grave or systematic violations of women's rights. In either case, states must be party to the convention and the protocol. The protocol includes an opt-out clause, allowing states upon ratification or accession to declare that they do not accept the inquiry procedure. Article 17 of the protocol explicitly provides that no reservations may be entered to its terms. 9. 1st April 2002 Public-Private Divide in Women's Lives. Tracing the history of the engagement of the women's movement with the law. Worldwide, the following important strands in the interface between the legal system and women can be noticed. 10. Most legal systems have features which are discriminatory to women, denying them equal rights to property, to certain kinds of employment, and so on. Even where there is de jure equality, law in its actual functioning discriminates against women because legal agents interpret laws in a patriarchal manner. Even when law treats men and women equally, it is discriminatory to women because men and women are located in an unequal position in cultural, social, and economic formations. In other words, it is unjust to treat unequals equally. The law and the state render invisible women's subjective experience of oppression, since objectivity is installed as the norm. In this sense, the law is essentially male and can only ever partially comprehend the harm done to women. There has always existed a divide between what is considered public and what is considered private in women's lives. The public realm is understood in this context to be open to government regulation, while the private is to be protected from such action, sexuality and the family being understood to be private. 11. Women's rights activists observe that this is a categorization which enables the judiciary to very conveniently not intervene in matters falling within the private realm, such as sexual assault and domestic violence. An example is the judgment of the Delhi High Court, upheld by the Supreme Court 12, in which it states that introduction of constitutional law into the ordinary domestic relationship of husband and wife will strike at the very root of that relationship, and that in the privacy of the home and married life, neither Article 21, right to life, nor Article 14, right to equality, has any place. There is now almost complete unanimity in the women's movement that this private-public dichotomy should be abolished, and that as far as women are concerned, the personal is political. In India, many women activists hold the view that it is necessary for the law to intervene in the recesses of the private to ensure justice. 1st April 2003 Gender equality under the Constitution. As far as Indian domestic law is concerned, the provisions for equality are vast. Articles 14, 15 and 16 of the Constitution of India lay down the conditions of non-discrimination, and gender is one of the important areas of non-discrimination. Yet there are a variety of methods in which both the letter of the law and various interpretations by courts discriminate against women. 13. Sometimes, the Discrimination is justified in the name of protecting women who are, after all, the weaker sex. Here are some illustrations as exemplified through case laws. 1. There is a rule under the Code of Civil Procedure that a court could ask a woman plaintiff in cases of money suits to give monetary security if she did not own immovable property in India. But in case of men, this rule only applied to men who are not resident in India and did not own immovable property in India. This means that there is a difference in treatment between men and women plaintiffs who are resident in India. Considering the situation in India, where most women do not own immovable property such as land and buildings, does this not cast a burden on any woman who wishes to sue? But it was held in Mahadev Geo 14 that though there was discrimination, it was not discrimination on grounds of sex alone and that possession of sufficient immovable property is not a consideration bearing on sex at all. 2. The Indian Administrative Services Recruitment Rules 1954 excluded married women from posts included in that service on the ground that marriage brings about certain disabilities and obligations which may affect the efficiency or suitability of employment. The court struck down such provisions in the rules as being discriminatory and against constitutional guarantees of non-discrimination on grounds of sex in matters of employment. 15. 3. Air India and London Airlines had prescribed norms for physical appearance, measured in literal terms for their air hostesses, who were required to be young, attractive, underweight and unmarried. If they married, pregnancy was barred. These rules were challenged and the court had the following observations to make. 16 Regarding the rule that women who joined the services as air hostesses be barred from marriage for 4 years, the court reasoned that this was a reasonable bar since it would help boost the country's family planning program and that since a woman would be mature at the age of 23, the regulation stated that they would be eligible to marry at 23 years. There are possibilities that such a marriage would be successful. However, the provision that an air hostess could be terminated on first pregnancy shocked its conscience. It felt that this was a cruel and careless act, and violative of Article 14 of the Constitution. It recommended, instead by some strange reasoning, that the rules be amended to state that termination on the third pregnancy if the earlier children were alive would be acceptable, again in the interests of the family planning program to control over population. It is remarkable that the first condition, that women were hostesses should not marry for 4 years, was considered reasonable by the court, when it is patent that the marital status of women and their pregnancy are considered a liability by most employers that affects their efficiency. Since men do not become pregnant, the rule regarding bar on marriage until 4 years of service did not apply to them. One of the fundamental precepts of equality, that those who are situated similarly should be treated equally, is directly violated. Since women are not situated similarly to men in respect of childbirth. Similarly, the recommendation that termination of the third pregnancy should be introduced in the rules shows scant respect for women's own reproductive choice. 4. The Punjab and Haryana High Court had to deal with the question of an order by the governor prohibiting women from employment in men's jails, except as clerks and matrons. 17 Even though Mrs. Singh was eligible for appointment as superintendent, her name did not appear in the gradation List and records of her employment carried a note that she was not encouraged with the superintendents. In general, she was considered unfit for appointment in a men's jail where hardened and rebel prisoners were confined. Women employed in these institutions, in this view, are potential victims of male crime, specifically male sexual crime, a possibility that even a prison cannot offer women protection against. The court assumed an absolutely neutral position to ask the question whether it would be possible for a man to be employed in an all-women's institution. Since the answer was no, the corollary would also hold true according to the court. It seems that the state is unable to offer protection to women against men, either in custody or in a position of authority. The above are just a few examples to illustrate the manner in which the law looks at women in India, using the lens of the Constitution. Perhaps the greatest site of oppression for women is in the area of personal law, i.e., laws governing marriage, divorce, maintenance, custody and property, which are based on religion. Thus, women from different religions experience differential treatment in these matters since Hindu, Christian and Muslim women have separate laws governing them in these areas. Some of these laws are more or less progressive, depending on how successful the individual religions have been in bringing about reform. The law and courts have been unwilling to go into this issue in great depth. While a uniform civil law covering women is desirable since it would help not to create discrimination amongst women as a class, the experience of the Indian women's movement has been that such uniformity will not take into account subtle and finer nuances that exist within the various religions. The argument has been that each religion needs to determine what areas of legal reform would best benefit women. This, however, is a double-edged sword as areas of law reform get debated and decided by the clergy and politicians who are predominantly men and whose interests lie in perpetuating patriarchy. In the Indian context, women have found it easier to fight against the state or against social custom through the state than to fight for their rights within the family or on personal issues, which bring them closer to the darkness of the inegalitarian and oppressive relationship between men and women. 18 On the other hand, since most of the new laws provide for more stringent punishment, there have been fewer convictions than before. Hence, only a change in the status of women in society and discarding the practices resulting from gender stereotyping will ensure that women get equal rights. 1.5 Summary. Let us now recapitulate some important points discussed in this unit. 9. While the sex of a person, being male or female, is determined by several biological factors such as genetic makeup, gender identity is something that has been constructed or ascribed to one by society. The ascription of qualities and behavior begins in the home and leads to considerable discrimination in treatment between boys and girls. 9. Since women's status and the way in which they are viewed have been shaped by society, it seems to follow that they will be subject to similar discrimination within the legal system and in the way they are viewed as legal subjects, and therefore, injustice outcomes. 9b discussed the effects of patriarchy in creating categories of productive and reproductive work and how such patriarchal control benefits men and makes it possible for them to control women. It is the visible labor of men which is paid work that is valorized by patriarchy, and the work that women do of childbearing and rearing is not valued and is consequently unpaid work. 9. One of the most important steps taken to advance the protection of women through rights and the law in the international arena is the adoption of the Women's Convention, CEDAW, which recognizes that a change in the traditional role of men as well as the role of women in society and in the family is needed to achieve equality between men and women. 9. Articles 14, 15 and 16 of our Constitution lay down the conditions of non-discrimination, and gender is one of the important areas of non-discrimination. Yet there are a variety of methods in which both the letter of the law and various interpretations by courts discriminate against women. Thank you. Subscribe to our channel for more updates, and we will see you with the next chapter.